Alex here with a legal nuts and bolts video on requests for admissions. In this video, I'm basically, well, first off, it's going to be a four-part series, 4 different videos on 4 different discovery tools. This one, as I mentioned with the title, is going to be covering requests for admissions. It's not going to be a long video because there's not a lot to go into. But as I mentioned, please watch the other 3 videos, and if you get a chance, watch the initial discovery video that I did a long time ago, so that you can sort of get an idea as to what I'm talking about. So requests for admissions, it's basically a legal paper with a bunch of questions on it. And in Nevada, if I remember correctly, under the NRCP, which is the Nevada Rules of Civil Procedure, the default number of requests for admissions that you can send your opponent is 40. Now I may be wrong and that may change, so please check for yourself. And I know that can be different in different areas of the law, so I'm not sure if the Justice Court Rules of Civil Procedure requires or defaults it at 40 also, maybe more, maybe less. And there may be other really quirky situations like in the arbitration rules or just other areas like that where it's a different number. And also, when you go to your case management conference, if I remember correctly, I believe that discovery is scheduled at that conference, and you can actually ask for the court to set a higher or lower number of the amount of requests for admissions that parties are allowed to send each other. So on to requests for admissions. Basically, it's a list of questions that you send your opponent, and your opponent has to admit or deny each question that you send them. They cannot answer it in any other way except to say, I admit this or I deny this. And obviously, if you think about it, these are great tools, because one of the things that happens when you sue your opponent, when you start the formal lawsuit process, so we're not talking about a small claims, because the small claims is like Judge Judy. You just basically show up and you talk and the case is closed. There's no discovery, no request for admissions, no nothing. I'm talking about a formal legal proceeding, and that includes, at least in Nevada, child custody, divorce, that kind of stuff. You're going to end up getting a discovery process, and part of that is request for admissions. You can imagine that part of the lawsuit is, what is my opponent going to say to certain things? I mean, it really is tough to present to the court your case when you just don't know which way your opponent is going to go. So requests for admissions allow you to send them a list of questions on something that you want to know what they're going to say in court. You want to know now so that you can plan how to deal with it. And when they get those questions from you, they're going to have to admit and deny each one. And then based on them admitting or denying, you can then decide, okay, well, I'm going to go in this direction. I'm going to need this witness. You know, they're denying that, so I'm going to need witnesses to prove it. You could send them something like, you know, I did not take my child to school 7 times last year, or something like that. And maybe they admit that. They told the truth. They said, you know, I admit that I didn't take my child to school 7 times. Well, now you don't need the witnesses. Now you don't have to prove that because they've just admitted it. You can imagine how immensely useful requests for admissions can be in cutting down the issues that your opponent is going to, or cutting down the possible paths that you may have to take in proving your case in court. Now, some people might think, well, maybe they'll just deny everything. Well, they can do that, but it looks bad. If they deny 14 or 15 different items and you prove so many of those different items, I mean, that is a lie. They are lying. They've been dishonest. So, you know, do they really want to lie about issues 4, 5, and 6 and then have it proved against them in court? And then the court gets presented with 2 other issues, and you basically say, you know what, Your Honor, I think you should rule in my favor on these issues. Here's my testimony and evidence. And by the way, those other 3 things they denied, it was obvious they did that. So they're a liar. You know, it's a great way to pin someone down. It's a great way to cut down on witnesses and work, basically, because you get to find out exactly what answer you're going to get on those issues. So there's one little extra nuance that I want to mention with requests for admissions. If an opponent does not answer a request for admission, or even all of them or some of them, the ones that they have not answered are deemed admitted in Nevada. That's a pretty big deal. You can't, if you fail to respond to these, if your opponent sends you requests for admissions and you don't respond to them in time, they could say to the court, well, these are all now deemed admitted. And so based on these having been admitted, I can win my case right now with summary judgment or something like that. Also, of course, because these are deemed admitted when they're not answered. You want to make sure that you ask them or state them in a way that if they're admitted, it's in your favor. You know, don't send them a request for submission like, I never forgot to take my child to school, because then if they don't answer that, it's deemed admitted. So it's like that just helps their case. You want to make a list of statements and questions such that anything that's admitted is in favor to you. So that way, just in case they don't answer any of it, you can just take that and go forward with it. So there's going to be all kinds of additional little quirks and details behind them. I can't really, bring them up right now. That's something for you to do research on. Hopefully, just knowing that this exists, you're able to, understand the process a little bit better, and hopefully, if you get served with them, you won't be totally freaked out. I don't know if I mentioned this, but if you are not in a discovery phase, you cannot just send these to your opponent. Don't just type them up and send them anytime you want. You have to be in discovery. Sometimes discovery happens automatically. Other times it's got to be opened. You got to ask the court to open it with a motion or something. But again, all these details are mentioned in the discovery video. So at this point, I'm pretty much done with requests for admissions. If anyone has any questions, feel free to post in the comments below or send me an email. And with that, I'll see you guys next time.